Committee this Wednesday afternoon, May 14th, and continuing to take some testimony on H44, which I understand this should be the language that we're going to be receiving later this week from the Senate. And there's a few changes, and I guess we're going to next hear from Marshall, if you can join us and run over the few changes that are in this.
So just to be clear, I'm not 100% sure that I have all the changes. The way that you said that made me unsure.
Three changes. And I can make sure that you.
Well, I picked up on, and I was prepared to testify about two of them, so I'll testify about the two of them. You can tell me which one I missed. So the two that I was prepared to testify about are, just to begin with, the change on pages 1 and 2. We are supportive of that, but I just wanted to kind of caution the committee, because what happens there is we're importing language from federal regulation. So in the past, this statute had kind of confusingly referred to another statute, which had in turn referred to federal regulation. That's always confusing when we do that, but sometimes we do that for a reason, which is it can be frustrating when we incorporate a federal statute by reference, and then the federal, especially when it's a federal regulation, which it is in this case, not a statute. Regulations can change very easily. And so when the federal regulation changes and we've incorporated that into a statute, it's essentially changing the substance of our statute without us knowing it. That's the way it was before. We've changed it in this version to actually incorporate the language from the federal regulation, which I think is certainly clearer, makes it a lot easier to use the law, but it also means that we need to be on top of any changes in that regulation. Whenever those changes happen, we need to actually change our statute, because now instead of incorporating the regulation by reference, we're actually taking the text of the regulation and putting it in statute. And this is an area where it's really important that our statutes line up with federal regulations precisely, because it's about commercial driver's licenses. And the point with commercial driver's licenses is they're all federally regulated. There's a commercial CDIS. There's CLIS or CDLIS is the Federal Commercial Driver's License Information System. It's like a separate court record system just for traffic violations for holders of commercial driver's licenses. And in order for Vermont commercial driver's licenses to be recognized federally, we have to make sure that all of our laws that touch on commercial driver's licenses match up with the federal regulations around commercial driver's licenses. We're doing that here, and that's a good thing. I just want to make sure everybody understands that when we switch to doing it by incorporating language rather than by reference, it means that we're then on the hook to kind of every year keep track of those regulations. And if they have changed, we got to change the language in our statutes where it can actually affect the validity of Vermont commercial driver's licenses. So not a problem, just a changed approach and one that we have to be aware of. So then we get to
Question schedule.
Is there any reason that referring to making the change by language rather than by reference would be preferred? Is there a problem?
It's a lot easier than having to go first refer from one statute to another statute and then refer from that statute to the CFR. Honestly, finding things in the Code of Federal Regulations is something that a lot of people struggle with. So it's certainly, I can pull it off. It's not something that's easy for somebody who's just trying to figure out what the law is and which offenses are actually reportable and which ones aren't. Really hard to do. So I like it when we incorporate the language in. It just means that we do have to stay on top of making sure that that language stays up to date with the federal regulations. As long as we can do that, from my perspective, it's the preferred way to go, because then we don't have to go hunting through 3 different jurisdictions' code books in order to figure out what the law is.
So this is a serious question. Who's the we you're referring to? As long as we can do that. Like if that's on all us, I'd be worried.
Well, I think it's on
practitioners.
Well, I think it's probably mostly the Department of Motor Vehicles, which is the because they're the organization that's really in charge of administering the commercial driver's license program. If something happened federally that made it so that our laws didn't align with federal laws, I would assume it would be them that would come in and say, there's been a change and we need a statutory change to address it. As criminal defense lawyers, we're not actually experts in CDL law. We certainly counsel our clients about it when they have somebody who has a CDL, if they have a charge that could affect their CDL. We counsel them about it, but there are people out there whose jobs it is to be lawyers who are specialists in making sure that you keep your commercial driver's license and trying to defend against disqualification. And they're out there and they do good work, and people who rely on commercial driver's licenses pay good money for that service because that's their livelihood at stake.
Coach.
There's two incidents that you see that occurring on a regular basis. When you see the all trucks right sign on the interstate, that's when you're getting your update. And if you're a commercial license holder and you don't pull over, you find out very quickly what you don't know. But if you stop, you get a chance to hear what's new. And then every summer for the CDL bus drivers, there's an update every summer. So for 35 summers, I went to that update. So it's on their house.
Yep, very definitely. That's a DMV thing. And we just think it was worthy of note that this is a change in approach in terms of how we incorporate the federal regulations.
I think we should have some comfort in that there's, I think almost every year, a miscellaneous DMV bill. That's in fact, I think the same language is in that bill, so.
Yeah. So it's just something that comes up. I know that we do it like on the juvenile side for our interest of justice hearings. We incorporate the federal code by reference because it keeps changing and we can't change quickly enough to keep up with it. So it's just one of those things that we do differently in different places in statute. And I just wanted to kind of highlight that was a conscious choice there to change the approach. The changes on pages 5 and 6, we support this. Just simply says that a person suspected of violating this section shall submit to the collection of an evidentiary blood sample when a warrant for that person's blood is issued. That's just a change from the negative to the positive. I think the original version said that they shall not refuse to consent or something along those lines. And this changes it to the positive, they shall submit. We think that that avoids any constitutional problems. There was the potential, in sort of how this developed in the Senate, it was sort of revealed that the idea that you shall consent is potentially constitutionally problematic. It crosses both First and Fourth Amendment issues. It's very rare that the Supreme Court allows the government to compel speech of any kind, to force somebody to say something. And that's what the language would have done. And this just flips it around to the opposite way. So instead of saying you shall make an affirmative statement of consent, it's more saying you shall not resist. And so we think that takes out the constitutional issues, so we don't have a problem with that. And that is sort of mirrored on page 9. There's a change to saying knowingly hinders the collection of an evidentiary blood sample when a warrant for that person's blood is issued pursuant to subsection F1. We think that change is perfect, that that's exactly what we need. Hinders is exactly what we were going for. Didn't have the wording quite right the first time around, but from our perspective, that is addressing exactly the issue. So those are the things that I had identified. I called that 2 changes because I considered the second one and the third one to be related to one another, but maybe that's all 3. Oh, and then there was the commission at the end, the task force. We're very supportive of that. We do think that the problem of how long it takes in detention for somebody to be processed through a DUI is problematic. We'd like to see what we can do to speed that up. And we think that a task force to get together and talk about all of the sort of choke points in that process and what can be done to alleviate them is a great idea. Something that hasn't happened yet. So we're supportive of that.
Okay, other questions? Any questions? No, thanks, straightforward. I appreciate
Thank
it.
you.
Yeah, thank you. And then we'll hear from Judge Zone.
Good afternoon. Tom Zune, Chief Superior Judge. We don't have any objections. The provisions that Marshall talked about may involve at some point the court having to define the parameters of them in the law based on any challenges that come in. So I really can't get into the specifics, but we understand what the language says and we will address it when the cases come to the courts. One thing that I did note, and this did not happen in the Senate, and it came across today as I was looking at this. I think if you're looking at draft 2.1, if you go to page 20, line 17, this is within section 5202 under orders of adjudication for delinquencies. And what this does is this language says that you have to send the notice of this adjudication to the DMV, to the commissioner, so that things can be taken care of.
Can you tell me the section? Just you may have
Section 3.
Section 3. Okay.
Notwithstanding subdivision.
Yeah, notwithstanding. So this makes it clear that the court is supposed to report a merits adjudication issued pursuant to 5229 of this title, who is alleged to have committed a violation of 23 VSA Chapter 13, Subchapter 13. So it's very clear, you have to report these specific ones. And it says pursuant to 5229. Then if you go to 5229 in section 4, it said the language that was added says, and shall send a record of the adjudication to the Commissioner of Motor Vehicles within 10 days. It doesn't say that the adjudication that you have to send a record of is limited to the ones that you referenced specifically in 5202. Although I think it's pretty clear that's the intent. And so do you follow me on that? That it seems much broader in 5229 that any merits adjudication has to be sent. And I don't think that's the intent. So you have a choice. The legislature can either, I think, and I would ask Marshall, because I'm sure he has a view on this. I don't even think you need it in 5229. Because you already specifically require it under 5202. Shall be reported with under 23-1709. And that statute requires the reporting to be taken care of within 10 days. So you already have it there. If you do nothing, what I suspect will occur is that the chief superior judge is going to tell the judges that you have a conflict in statutes. And I would tell the court administrator, the trial court operations, that it is very clear that the intent is that we only report DMV cases that meet 5202 because it is more specific.
And I would agree with that and clarify that by removing the section from 5229 about the reporting to the Commissioner of Motor Vehicles because it is already also in statute. I was just in a meeting today discussing with Department for Children and Families and Department of Corrections the potential for spending the next year rewriting chapters 51 and 52. And part of what we talked about is that we have many instances in statute where we have duplication of procedural things and we don't actually duplicate them in the same exact way. We get them slightly different in different places in statute. And we all agree that it's time to rewrite the whole statutes just for the sake of clarity and to address situations like this. So I think I agree with Judge Zone. This could be corrected by removing that section from 5229. But I think that's reflective of a problem that pervades the juvenile statutes and that we're working on actively.
But if that train has left the station,
Well, no, not necessarily. You can catch it at the next station downstairs before third reading. If I can, even though they don't meet in the afternoon, but it's possible to get that fix before their third reading in the Senate.
my thought is that we can also take care of it with our operational procedures, because it is clear what the intent is with that.
So the other option is that, it's just a calendar timing of this. And I'd rather not have this go back to them from here, just because things get lost in processing, it seems at the end of sessions. Yeah, that could be it, and we could make a point of fixing it in the miscellaneous bill next year.
Because it does appear to be very clear what you're doing.
Yeah, so I wouldn't bother with running.
Okay. So I will, I just didn't want there to be any surprise.
Yeah, so if it's something that can wait for a fix in the miscellaneous bill next year. And you'll fix it operationally, but
But I will, yeah.
as far as the
And
language.
interestingly enough, I think this problem arose because of the way the operational side was doing things. Some judges were saying should be one way and some were saying it should be the other. And this makes it very clear. I think we can handle this operationally. I will work on that.
All right.
Beyond that, nothing else on this bill.
Well, I appreciate any questions. Anybody have questions? No? All right. Thank you very much.
All right, thank you.
So we are going to go back to S12 momentarily, but I know that Tom wanted to be here for that. I assume.
So we're gonna put the other top statute into law that reflects the law.
Can I get some of what happened?
Now I see how it happens.
I'm going, is this?
Somebody with that question.
Yeah, you got, get Ann down here. You go, I don't understand. 5220 he seems to be saying one thing, and then subsection 3 on page 1 seems to be saying something else.
Agreement on the thought, like, yes, and it's gonna be dealt with this way, and we're gonna do a miscellaneous bill.
Two things. One, remind you, we are still on live. And two, this side by side for 44 is on the website. I can print it out.
Thank you.
I'm happy for that to be on the recording.
I knew that we were live. I showed, I appreciate the reminder.
Oh, put my mink on live? No, because I don't, my wife's not gonna watch this, but it's a surprise, so.
Oh, yeah. Forty-four, I know, I have the extra copies of 44. No, I needed this one, 12.